Okay, good morning everyone. Our next panel is going to be about victimization of Kurds by the current Turkish law. It's going to be divided into two parts. So the first part is going to be started by Dr. Darren Dinsmore, who is a lecturer at the University of Kent and has previously taught in the law schools at Queen's University Belfast and Keele University. Darren holds an LLB in Law and Government from University of Ulster and an LLM in Human Rights Law from Queen's University Belfast. In 2005, he created a Turkish human rights information site website based on his master research dissertation for the Human Rights Centre at Queen's University Belfast. In 2012, he completed a PhD at Queen's University Belfast entitled Forced Movement and International Human Rights Law, a case study of the European Court of Human Rights in Turkey. It examines the Turkish village destruction and village return cases at the European Court of Human Rights. And his paper is entitled Internal Displacement in Turkey, Shortcomings in International Oversight and the Domestic Implementation of Human Rights Law.
Thank you very much. What I just want to do this morning is to contribute to discussion on the role of the Human Rights Court at Strasbourg when it comes to dealing with the situation of human rights in Turkey through the conflict in the 1990s, with a particular focus on the issue of internal displacement. Now, the European Court of Human Rights played a pivotal role throughout the 1990s in exposing and addressing, or at least attempting to address, widespread human rights violations in eastern and southeastern Turkey, and in particular took a leading role in developing human rights jurisprudence on the topic of internal displacement. Quite simply, often it was the case that the European Court of Human Rights was the only place for people to turn to for the protection and vindication of their rights, and also, quite importantly, to be heard. And when we look at internal displacement, it becomes quite apparent. We get a very clear signal of the social, the economic, the psychological impact of the conflict, and again, the very troublesome human rights practices that were occurring. Internal displacement as a human rights issue is very difficult for a system like the ECHR to get to grips with. And when we look at Turkey, there are a couple of specific problems that Human Rights Court at Strasbourg faced. First of all, the scale of the problem. Numbers of IDPs, or internally displaced persons in Turkey, is a controversial issue. Some international and domestic estimates put the number at around 1 million, at around 1 million people. Some NGOs, such as the Kurdish Human Rights Project, have put the number much larger, at between 3 and 3.5 million people. In addition to the scale, there's also the problem that it is a protracted situation of displacement in Turkey. A large proportion of the IDPs in Turkey fled their homes during the height of the conflict around 92, especially 93, 94. Okay, so many of these people have been displaced from their homes for 20 years. There are generational problems to this. In terms of getting to grips with displacement, this was conflict-induced displacement. People fled due to insecurity, due to conflict, due to attacks, whether by state and non-state forces. Other people fled their homes due to the general difficulties of life. The social and economic conditions became very harsh. The inability to farm through controlled movement. There are a lot of things that lie behind the displacement situation in Turkey. One particularly important thing is the village guard system, just very briefly, and I'm sure there's a lot of knowledge on a lot of the matters I'm discussing, but I do want to just give a little bit of background before getting to some analysis. The village guard system, as many of you know, was essentially a series of local self-defense forces whereby villagers were required to defend their village against PKK operations and were armed and participated alongside security forces in operations against the PKK. So we see we have this large-scale, protracted displacement born of conflict, insecurity, and there was a lot of fear and mistrust of the state. So getting to grips with this was never going to be easy for any internal or external actor. But what I just want to assess briefly this afternoon is the role of the European Court in trying to do that, in addressing the issue of internal displacement. And I want to consider just what standards have been set for Turkey, what does the European Court require Turkey to do, and how far are we towards dealing with this very difficult human rights problem. I just want to use this map very briefly to make the point that there was a very distinct geographical focus. As many of you know, these provinces in east and southeast Turkey, sort of checkered provinces on this map, were under a state of emergency rule from 1987, a number of which were remained under state of emergency rule until 2002. Okay, within a broad range of emergency powers, there were restrictions of many rights, but particularly on movement, and there was a basis for what the Turkish government referred to as security-related evacuations. Many people fled their homes within this region and stayed within this checkered region. Others moved to provincial cities or other towns. It is quite to a large degree an a rural to urban movement. But it is these border provinces in which displacement was felt most harshly by citizens. More than 2,000 applications were lodged at the court complaining of the destruction of villages and forced displacement throughout the 1990s. At this point, there were no comparable cases in human rights law internationally. The Inter-American Court had no similar cases. We have a large body of jurisprudence now across a number of international institutions. The European Court had nothing to draw on. There were no established norms on forced displacement. We now have UN guiding principles. So there are a number of problems the court faced. The number of applications, the alleged systematic practice of forced displacement, individual applicants' claims, represented by the Kurdish Human Rights Project in particular, are really situated within an alleged general practice of displacement. The ECHR system has long been notoriously poor in addressing generalised or systematic practices. So when taking these claims, applicants and the KHRP were very much trying to push the ECHR system to respond in the most difficult of circumstances and in legally difficult cases. There was a clear strategic concern of the KHRP to establish a denial of remedies within the emergency region. This applies as much to the right to life and forced disappearance and torture cases as it does to village destructions. So again, it is important that not only were individual claims lodged about the destruction of villages, this was all set within a very, very broadly conceived strategic policy of litigation. Just briefly, the typical claim would be that security forces or village guards came to applicants' villages, destroyed property, destroyed livestock, destroyed farming equipment, and forced people to leave. Sometimes this was what human rights organisations refer to as a scorched earth policy. Clear people out, remove logistical support for the PKK. It could be alleged to be punitive in relation to refusal to join the village guard system. Applicants did portray a number of motivations behind these alleged violations. Now, with this strategy to expose a lack of redress, the KHRP achieved in getting something very special from the European Court of Human Rights. They got a special, unique form of oversight. The European Court accepted that investigations into alleged destruction of villages were not effective, they were not prompt, they were not independent, and set aside the rule that you must first exhaust domestic remedies before coming to this international court. This was a very unusual decision for the court to take. In a number of cases, they accepted applications where no domestic claims had been lodged. Okay, so there was an effort to create a sort of bridge of petitions from those southeastern provinces all the way across to Strasbourg. And Strasbourg, surprisingly enough, said, accept these complaints. In doing so, the European Court of Human Rights created a bit of a problem for itself. Having found there were no effective investigations into these alleged violations, having established, therefore, there are no facts established at the local level, this distant international court then had to try and get some facts for itself. And this is where we get probably to the most unique and innovative aspect of international law in Turkey and the ECHR in Turkey. Beginning in the mid-1990s, the European Court began certainly an unprecedented program of in-country fact-finding. So, through the course of 45 days in 16 village destruction cases, delegates of the European Commission and the European Court of Human Rights heard evidence and oral testimony from witnesses in Turkey. 201 witnesses. Applicants had the chance to be heard. Witnesses, other members of villages, had a chance to be heard. State security officials, politicians, police, gendarmerie provided evidence to the Commission and to the court. This was the first time we had a chance to establish an independent record of what was going on in Turkey. There were reports. The Council of Europe said there were some, to Parliamentary Assembly rapporteurs of the Council of Europe said in 1992, there are many indications of violations, but it's here that we actually got something substantive in terms of a narrative and a record. You might also consider fact-finding to be a form of remedy itself for applicants. Again, the chance to actually be listened to, the chance to see your case being put to the state representative in the room in front of you. Now, of course, the ECHR bodies encountered a number of difficulties in this process. They could not compel the state to provide documents and to provide witnesses. There was the issue of consecutive interpretation between Kurdish, English and Turkish. And there was an inability to really actually get to the general pattern of what was going on. 16 cases, 16 incidents of destruction were examined out of many more reported incidents and many more claims that were taken under the ECHR. What we do get is, although these are individual applications, we do get evidence, not just what happened to this one individual as part of the alleged destruction. We get a sense of what was going on in this village, what was going on in the surrounding area. But in EPEC, for instance, the European Court of Human Rights said, this operation happened within the framework of a much broader, much larger security operation in the area. And they were not able to get evidence to that. But simply, they did not have the capacity, the time, the resources to actually follow through in establishing facts, or in fact establishing truth of what was going on. But nonetheless, by allowing direct access, by, for the first time in individual cases, going and undertaking fact-finding in a conflict area, this was something innovative, it was something important. There are structural limitations to what it could deliver, but I don't think necessarily that undermines the importance or validity of the process whatsoever. We have to remember there are limits to what a human rights court can do, of course, in these circumstances. But it was no one else, it was the European Court of Human Rights that did this, not a UN body, not the European Union. It was particularly the European Commission on Human Rights, but it was the Commission and Court that really did this. Perhaps the structural limitations of the ECHR system become more clear when we look at what happened next. What did the court find? The court recognized in individual cases there were serious or grave violations of peaceful enjoyment of possessions, of the right to private family life. There is no right against forced displacement in the ECHR. But they were not willing to go any further. The European Court said there is no evidence of discrimination in these cases. There is no evidence of a systematic practice, and we will not entertain these allegations any further. Perhaps more importantly, and looking at it from international human rights law, the court found there were acts of violence. The court found the people were obliged to leave their homes, but at no point did it say this is forced displacement. At no point did the court set standards of behaviour. at no point did the court seek to elaborate what are the rules on the ECHR when it comes to an area of conflict. How far does the state have to go to protect people from being displaced? And we may consider the obligations in regard to the actions of non-state actors as well, to the PUK. So there is a bit of a jurisprudential black hole. The court found the property was destroyed, large numbers of people were obliged to leave. Unlike now, we have some wonderful jurisprudence in the Inter-American Court detailing the obligations on states in this context. The European Court really did not want to deal with that issue whatsoever. And just briefly, remedies from Strasbourg were very limited. The European Court of Human Rights, as many of you know, can only offer just satisfaction, which is compensation. It could not provide for redress. It did not call on the Turkish government to provide for resettlement. It did not call for any more detailed measures of reparations to be taken. So it essentially stopped with the judgment. This all takes us up until around the end of the 1990s, and around 1999, obviously, there were some important domestic developments. The changing situation in Turkey really can be seen in how the European Court changed its approach. So if we look at, we consider the capture of Abdullah Öcalan in 1999. We consider the Helsinki decision to formally recognise Turkey's candidate status for the EU. Leading up to 2002, the end of emergency rule, the European Court really responded to changing local conditions. One way it did this was the increased use of friendly settlements. There is clear evidence that the Council of Europe decided to settle cases before they came to the court through ex gratia payments as a means of engaging Turkey in dialogue, rather than establish this series of critical judgments. Around the same time, we also had the European Court shut down its fact-finding. This actually coincided as well with the 1998 transition to a full-time court at Strasbourg. So as we got a more established independent judicial redress, we got a more pragmatic and diplomatic approach in dealing with Turkey. Diplomacy is something that is always a problem with the Committee of Ministers. We have these very detailed fact-finding decisions. We have some strong language on the responsibilities of the state for destroying property. When it came to the Committee of Ministers' oversight of these judgments, internal displacement was nowhere, forced displacement was nowhere. There was a focus on future-oriented reform. There was a focus on training the security forces and the regulatory oversight of action of the security forces, which was, of course, crucial in bringing the cessation of these types of acts. But this was quite a technical process. The forced displacement itself wasn't explicitly addressed by the court, and neither was it addressed by the political bodies at the ECHR, or of the Council of Europe, excuse me. If we look beyond 2002, there is an improved diplomatic relationship with Turkey. The UN Special Representative on Internally Displaced Persons, Francis Deng, was allowed to visit Turkey in 2002 to conduct a fact-finding mission and report on the situation and needs of IDPs. This was a very important moment that quickly led Turkey to recognise there is a problem, something will need to be done here. As of 1999, we had already had a symbolic move, a proposal from Turkey to facilitate return and resettlement. This was not sufficiently planned, there was insufficient consultation, and the court itself found that Turkey had not really effectively sought to implement this programme. But in 2004, following the calls of Francis Deng and sending out a sort of roadmap essentially for Turkey to deal with its displaced, we had this compensation law, and this is the cornerstone of Turkey's efforts to date to address the problem of internal displacement. It is a response to the Deng report, to the European Court judgments, and of course to the EU accession process. Parliamentary debates made it clear this system was specifically to assist IDPs, but when you look at the title of the compensation law, we see the fight against terrorism, losses resulting from terrorism, and the fight against terrorism. I'm wondering, perhaps, I know there are a couple of translations of the title of this law, forgive me. But what we have is, this is based on social risk, this is based on the objective liability of the state. This is a compensatory scheme. It is essentially a domestic-friendly settlement process. It entails no acknowledgement of any past responsibility. The preamble states the aim of this law is to deepen trust in the state, to strengthen the state-citizen relationship, to contribute to social peace, and to the fight against terrorism. Unfortunately, there is nothing in the compensation law to facilitate social peace. There is nothing there to re-establish trust in the state. And again, this does seem, perhaps this is a cynical viewpoint, it is a large-scale measure, and it is attempting to deal with a very serious and very difficult, long-standing problem. But again, this is based on compensatory redress. It is not based on a full, holistic approach to the problem, and necessarily a human rights compliant approach to the problem. Within a year of this system being set up, the EU started to have some problems and some concerns. Some restrictive eligibility criteria. Problems became apparent with hierarchy of victims under the system. There was a fundamental issue of the evidential burden on applicants. Can you establish you own property in that particular area? It's a fundamental problem that still blights the compensation law. And there were concerns about the level of compensation to be paid. But while the EU had concerns, the European Court of Human Rights was surprisingly happy to accept the compensation law. The European Court of Human Rights in ECHR found, well, there have been 170,000 applications lodged. There are assessment commissions set up in almost 80 provinces within Turkey. And this is an effective remedy for IDPs. Now, in the past, Strasbourg had been very keen to say, you must investigate what happened. And that was quite an important aspect of their oversight. But the court seemed very, very eager to get rid of 1,500 cases from its caseload. It seemed very eager to facilitate dialogue with the state. And it should be added, the ECHR decision is quite brief. It's quite technical. It doesn't really necessarily explore the issues. The Internal Displacement Monitoring Centre and Norwegian Refugee Council, two very highly esteemed expert bodies, shortly after ECHR, continue to say the same things the ECHR had said previously. There are problems with eligibility, there are problems with the rates of rejection, there are problems with the evidential burden. And we see just a brief comment from Human Rights Watch that suggests that in fact, rather than restore social peace, this compensation scheme might harm social peace. The Committee of Ministers, again, political oversight of the ECHR judgments, was not particularly effective. The Committee of Ministers shut down its assessment of the situation of IDPs in Turkey in 2008. There was therefore no follow-up, no running oversight of the implementation of the compensation law. Having assessed quite early in the process in ECHR that this is fine, that was the end of the oversight. It remains the UN Development Programme, and it remains for the EU to shepherd this process towards being effective and effectively implemented. And just one point that is quite interesting. Recent data and qualitative data with IDPs in Turkey suggested from certain results, awareness of the European Court of Human Rights among IDPs, somewhere about 79 to 80% awareness of the European Court of Human Rights. Awareness of the compensation law, about 50 to 53%. Human Rights Watch might be a little bit off the mark in their assessment of the impact. There is not sufficient awareness, visibility of this quite large system that so far more than 380,000 people have applied to. It's also not politically an issue that is particularly aware within Turkey, and it's not something yet that really is gathering a lot of attention. If the state is to restore social peace in dealing with its IDP situation, I just want to very briefly mention these UN basic principles, and also we can think of transitional justice approaches. Okay, reparations is conceived of as including restitution, in this instance, enabling people to return home. Compensation, we have a compensatory approach. Rehabilitation is missing from the compensation scheme. Satisfaction, the idea of acknowledgement of responsibility, perhaps some form of truth-telling, perhaps some form of public apology, is absent in its entirety. And guarantees of non-repetition. Removing the village guard system, which would be no easy step, but there has been significant pressure on Turkey to do this for a number of years. Dealing with the infrastructural problems. The government is very keen to speak of dealing with IDPs as a developmental issue. Clearly, development infrastructure is important for those IDPs that do wish to go back to their places of residence. But again, the problem is that the compensation law, it's not ambitious, it's not set up to in any way address this need for social peace, to re-establish trust in the state, and to actually facilitate and resolve the situation of Turkey's IDPs. Here we have the president of TOAV, Domestic Human Rights Organization, making the point very clearly: we cannot have societal peace and social justice by paying compensation. Especially in cases of death, applicants are not seeking compensation. They want truth-finding and acknowledgement. There is nothing about this in the law. Just in July 2011, the European Court of Human Rights received a series of applications making these points in a number of ways, questioning the independence of assessment commissions, questioning high rates of rejection, the evidential burden. The European Court of Human Rights has signed off on the project again. In regard to more than 200 applications, it said in July 2011, this is an effective remedy. We can only expect the Turkish government to respond to the pressure put on it and to what measures are called for by external actors. The European Court of Human Rights has signed off on this. The EU, the Internal Displacement Monitoring Centre, international local NGOs maintain there are significant problems with the process. Unless we really try to get to grips with what happened so long ago, unless there is a political process that we can tie together with the issue of internal displacement, poverty, lack of education, distrust of the state, these very fundamental problems that IDPs in Turkey are having are only likely to continue.